8 of the Arbitration. That there is Section 8 of the Arbitration and Conciliation Act. Section 8 of the Arbitration and Conciliation Act says that if there is an arbitration agreement between parties and yet one of the parties to the agreement takes that dispute to the court will not proceed with the dispute, will not hear the case, but will redirect the parties back to arbitration, saying, look, you have an agreement to arbitrate, please go arbitrate. Now, does a similar principle apply when parties have an agreement to mediate? That is the second. Should we enforce it? Evidently, if one of the parties who is a party to the mediation agreement takes the dispute to court without going for mediation, that party is not interested in mediation at that point in time. So should the court say, no, I'm not going to take up your case, please go attempt mediation and come back? What should the policy be on that? Are we forcing a party who's not interested in mediation to go for mediation? So that's a second type of mandating mediation. The third policy sort of basis for mandating mediation is to say that if you file a case in court and you don't participate in mediation, then the costs of the litigation will be borne by you. If you win a case, you could have obtained costs of the litigation from the losing party, but no, you did not participate in the mediation. If you participated in the mediation, there was a likelihood that you could have settled, but since you didn't, you please bear the cost of the litigation yourself. So this is the third. So this is the third I refer to as a sort of a backdoor way of mandating mediation. So you have the likelihood of costs hanging at the back of your head, and therefore you choose to go for mediation, right? Not you choose. Therefore you say, even though you may not have been interested in the mediation really, you go for the mediation because you say, well, this is a way of making sure that the costs are not on me, right? So let's look at the first way in which mediation is mandated by the court, by policy. We will look at the Italian law, and then we will look at our Commercial Courts Act. So the Italian law, I had shared a document. The name of the document would be Leo D'Orso, the Italian Mediation Law. So if you can open it, we'll just refer to a few sections there. Let me know once you have it. If any one of you gives me a thumbs up, I will proceed. Please let me know if you have it, then I'll start. Okay, thank you. So this is a law that was passed by Italy in 2013. In 2010. The European Union had passed a regulation where they said that if countries in the European Union must encourage the use of mediation in civil and commercial disputes. And they said you must, in your national policy, make a policy to recognize mediation, define mediation, provide infrastructure for mediation, and in your policy encourage the use of mediation as well as norms for mediation such as confidentiality and enforcement of the mediated settlement agreement. It left it to the countries to frame what their policy around mediation would be, but said, please make your policies relating to mediation. It also said it is up to the country to decide if they want to make mediation in civil and commercial disputes mandatory. Now, Italy decided to make mediation mandatory, and they passed a law. This law was challenged by the lawyers in court, saying that this affects the constitutional rights of litigants. And we'll come to this constitutional right in a minute, once we've looked at these two policies. And the Constitutional Court in Italy said that this was a bad law, that this law was unconstitutional. They didn't go into this decision because it interfered with a person's right to go to court. But they said that this is a law which procedurally there were certain things that ought to have been done that was not followed, and therefore it was unconstitutional. So what Italy did was to use this decision by the Constitutional Court to go to the drawing board again and to rework their policy. And they came out with a reworked policy, which is what is in front of you. And there were 3 sets of regulations made. The first regulation is that before certain types of cases are filed before court, and the law identifies this, before these cases are filed before court, you must go for mediation, and you must go for 1 session of mediation. And if you are not able to settle, then you can file your case in court. If you settle, then of course, the law recognizes this settlement agreement as if it were enforceable. The second set of regulations that they made was a system of training and accreditation of mediators and mediation service providers. They worked on setting up the sort of resources and the infrastructure, if I may call it, of mediators in the country, so that when you tell a person, look, this is the law that you have to go for mediation before you file a case in court, there must be trained mediators available. So the focus of this regulation was to set up the infrastructure for mediators, right? Training, etc. The third limb of the law, the third regulation, related to the mediation process in terms of how the mediation would be conducted, training for mediators, who the trained mediators would be. It insisted that when there is a mediation that is going on, the parties must have their lawyers present, so that the lawyers are able to advise them on whether the settlement they are looking at and considering is a good settlement, will stand in law, will protect their rights sufficiently, and therefore lawyers must always participate in the mediation. Right? So these 3 limbs of the law were what the regulations made in 2013. We're going to look at only the first limb because our discussion today is on mandatory mediation. So what I have shared with you is a translation of these 3 regulations. This is not an official translation. This is just a translation of persons who are interested in this, and therefore you will find that the language is not very clear. It's a very forced translation. You might find some repetition, but this is the best I have been able to access, so this is what I share. Okay, so if we'll go to page 9 in the document. This is chapter 1, and this is the legislative decree March 4 of 2010, but the amendment was in 2013 to make it the way the law is today, right? So I'm only referring to Article 1, subparagraph 1, to see what the definition of mediation is. Mediation refers to the activity, however named, carried on by an impartial third party that aims to assist 2 or more parties in finding an amicable settlement of a dispute, including the formulation of a settlement proposal for the resolution of the dispute, right? So this is the definition of mediation. We'll then go to Article 5. This is the provision that speaks about mandating mediation. So Article 5(1) bis says, prior to the initiation of legal proceedings and with the assistance of legal counsel, those who intend to commence legal proceedings in a court of law in an action related to, and these are the sort of types of disputes for which mediation is mandatory. in an action related to a dispute concerning a matter of joint ownership, real estate, partition, inheritances, family covenants, lease, bailment, business lease, damages for medical practice, malpractice or defamation via the press or any other means of publicity, insurance, bank and financial contracts are required to participate in the mediation procedure foreseen in this decree or the conciliation procedure provided by legislative decree on October 8, 2007. So before you file a case in court, you must attempt mediation. That is the mandate of this law. And a few lines below that says the attempt at mediation is a condition precedent for legal proceedings. Okay. This was intended as, as an experiment for 4 years, as a pilot for 4 years. But now this decree is still, continues to be enforced. They have extended the application of this decree. Now, I'm now going to paragraph 2, subparagraph 2 of Article 5. This says that a court, whether in the appellate division or at the first time that it is hearing a case, the court can look at the case and say, look, I think this is a case that can go for mediation, and direct the parties to attempt mediation. So this is a power given to the court independent of this mandate to mediation, where any case that comes before the court, if the court thinks that this is a good case in which parties will be able to settle, it can direct the parties to go for mediation. I come to the next paragraph, which is 2 bis, which says when mediation is a condition precedent for legal proceedings, the condition is considered satisfied even when the initial meeting with the mediator ends without an agreement. So all that a person is required to do, or parties are required to do, is participate in one session of the mediation. If they have participated in this one session of mediation half-heartedly, with no interest, and they decide, no, mediation is not for us, they can terminate the mediation. Any one of them can terminate the mediation, and then they can go back to the court, right? Then we come to paragraph 3. The mediation procedure does not prevent in any case the granting of interim measures, including protective measures, or the publication of the claimant pleas. Okay, so if I have something urgent that I want from the court, let us assume I am the person involved in the dispute and I want an urgent order from the court. I don't have to go for mediation first. I can apply to the court and ask for an interim order to be ordered. And then the court has the power, like I mentioned earlier, to direct the parties to go for mediation. Therefore, let's assume my neighbor is building something on my property. And I want that to be stopped because I don't want the construction and everything to be completed, because then, I'll have to put up with it till the end of the litigation. So I applied to the court upfront saying, look, he's in the wrong by building something in my property. And so please stop him from continuing with this construction, right? So I'm seeking an urgent interim order. So if there is something of that nature that I require in my case, I don't have to go for mediation first. Even in those compulsory categories, I can go to the court and apply for my interim order. Then we come to subparagraph 5. In subparagraph 5, this talks about any other statute or the agreement between the parties saying that they will first attempt to resolve their disputes through mediation. If that is their agreement, or if the statute mandates that you must go for mediation, nevertheless, the party files a case. And this is not just in those compulsory cases, this is in any case. The court will stop the proceeding and ask the parties to go try mediation and come back, right? I just want to see if there's anything else here that I want to look at. The other provisions in this regulation talk about if there is limitation that is running out, the time taken by the parties for mediation will be excluded from the period of limitation. So I just want to check with all of you if you know what limitation means. If there's anyone, please raise your hand, and then we'll just go through that briefly.
Yes, madam, we have discussed earlier also in earlier classes.
Okay, that's great. Thanks. So your period of limitation will be at a pause while you attempt mediation. That's another provision in this law. If you read the rest of these translations, the entire law, we don't have the time to read all of it, but if you read it, you will find that there is provision for training of mediators. Lawyers automatically are entitled to be trained mediators. You find that lawyers have to attend all the sessions of the mediation, because the effect of a mediated settlement agreement is that it will be enforced as if it were a decree, and therefore, in order to ensure that the parties' rights are safeguarded when they participate in the mediation and when they enter into a settlement agreement, there is a lawyer always by your side to guide you on whether you're doing the right thing or not, right? There is a provision in these regulations for someone called an auxiliary mediator. So in the last class, all of you introduced yourselves, and you said some of you were engineers, some of you were contract specialists. We have a psychologist in the group, or a psychiatrist in the group. You have a certain expertise. Now, in certain disputes, this kind of expertise comes into play. Let us take, for example, medical malpractice. Right. So this law says that if it's a case of medical malpractice, you must take it for mediation compulsorily. Now, if you have someone who has a training in medicine, this person will be able to understand issues better, will be able to intervene, or probably even guide the parties in terms of how strong their case is or how strong their claim is, right? So what the law says is that there will be these mediators who are called auxiliary mediators, who will be subject matter experts. And if parties choose to get someone who will evaluate the dispute for them or with them, then the mediator can call upon an auxiliary mediator who is a subject matter expert to come and participate in the mediation and to do an evaluative mediation with the parties. So these are sort of the details. There is a slab for what the fees for mediation will be. There are provisions that say you will get tax incentives if you participate in mediation and settle. So it's a very sort of, there's a lot of detail in this law on the setting up of mediation facilities and therefore directing the parties to attempt mediation. The topics that we saw that were covered in mandatory mediation have been extended. There are more areas or dispute verticals that have been covered in mandatory mediation. In Turkey, we have a law that says that employment disputes must mandatorily go for mediation before they take the case to the court, right? So this is the law in Italy. We now will go to the Commercial Courts Act. Again, the link was shared with you. If you've got it, a thumbs up from any one of you, and then I'll proceed.
Excuse me, madam, what we have to look for?
Commercial Courts Act.
Commercial. Thank you.
Yeah, okay. So this is a law that was passed in 2015. There was a lot of, and there continues to be um, a lot of sort of complaints and a very poor opinion of how much time is taken in our courts to resolve disputes, right? So internationally, Indian courts don't seem to have a great reputation in terms of speed of resolving disputes. And so the World Bank had this system where it would evaluate every year uh, the ease of doing business in different countries. And it had certain metrics on the basis of which it would assess the ease of doing business. One of the metrics in which it looked at the ease of doing business was resolution of commercial disputes. And India wasn't ranked very high. It was pretty low in the ranking because of the time that it took for cases to be resolved. There is a problem with how this is assessed because, for instance, the way they did it in India is they look at how long cases take in Mumbai and in Delhi and they say, okay, this is the norm. So in terms of rigor, in the way in which they are assessing what is happening in the country, it's not great. For instance, if we have a law on insolvency and bankruptcy, we get this many points, so we jump up, right? So we do have a law on insolvency and bankruptcy, and lo and behold, the next year, our rankings shot up. So it's not very rigorous, but it was decided that we must pay attention to how quickly commercial disputes are resolved in our country. And so the Commercial Courts Act was passed in 2015, and very broadly what the law does is it provides for the establishment of commercial divisions and commercial courts. And these will be specialized courts that will deal only with commercial disputes. And there is a lot of sort of emphasis on infrastructure, on staffing of these courts with people who are familiar with commercial disputes and who are able to understand and resolve these commercial disputes very quickly. The Schedule 2, the law, has an amended version of the Civil Procedure Code where the various stages in the Civil Procedure Code for filing of your written claim, if I might call it that, which is your suit, the filing of a reply, the evidence, the resolving of interim applications, all of this is on a very tight schedule. There is a tight time limit so that, and the processes that are there in the Civil Procedure Code, the timelines are compressed so that commercial disputes can be resolved very quickly. If you don't file what you're supposed to file within that time, you have a small period, a small window of extension that you will get. And if you don't do it by then, well, your right is lost forever, right? Of what you can do in the court. So this is broadly what the Commercial Courts Act seeks to do. And there is a definition of what commercial disputes will be, and we'll look at it in a minute. In 2018, this law was amended, and Section 12 capital A was introduced in the Commercial Courts Act. And this Section 12 capital A, what it does is it says, before you file any commercial disputes in court, you must first go for mediation, attempt mediation, and if it fails, only then will you file the case in court. Okay, so we look at what the contours of this policy are, but first, what the definition of commercial dispute is. So if you look at Section 2, subsection 1, there is a paragraph 1 next to it, and then if you come to subparagraph C, small c, it will start with commercial dispute means a dispute. So commercial dispute is defined as a dispute arising out of ordinary transactions of merchants, bankers, financiers, and traders, such as those relating to mercantile documents, including enforcement and interpretation of those documents. Then there are many other types of commercial disputes that are given. One is partnership agreements. I'm not reading all of them, just so that you get a flavor of, what are the disputes that are covered in commercial disputes. I'm just pulling up a few. So partnership dispute agreements, joint venture agreements, shareholder agreements, distribution and licensing agreements, carriage of goods, construction and infrastructure contracts, insurance and reinsurance, contracts of agency relating to any of the above, agreements for sale of goods or provision of services. So these are the types of disputes that are covered under this law. We now come to section 12, capital A. The other thing here is that this law covers disputes of a certain specified value. And this specified value is 3 lakhs and above. So any dispute, commercial dispute of a value of 3 lakhs and above will be covered by this law. Okay, so we come to section 12, capital A, and this we will read in a little bit of detail. Pre-institution mediation and settlement. A suit which does not contemplate any urgent interim relief under this Act shall not be instituted unless the plaintiff exhausts the remedy of pre-institution mediation in accordance with such manner and procedure as may be prescribed by rules made by the central government. And the central government has made rules called the pre-institutional mediation rules, PIMS rules. So what is the substance of this? If you have a case which relates to a commercial dispute, and this case does not contemplate or require any interim relief, you cannot file this case, you cannot institute this case unless you attempt pre-institution mediation in accordance with the rules. Then paragraph 2 in section 12, capital A, the central government may, by notification, authorize the authorities constituted under the Legal Services Authorities Act 1987 for the purpose of pre-institution mediation. Paragraph 3, notwithstanding anything contained in the Legal Services Authorities Act 1987, the authority authorized by the central government under subsection 2 shall complete the process of mediation within a period of 3 months from the date of application made by the plaintiff under subsection 1. So there is a time limit within which the mediation will be completed, which is 3 months, provided that the period of mediation may be extended for a further period of 2 months with the consent of the parties. So 3 plus 2 months within which you must complete the mediation. Provided further that the period during which the parties remained occupied with the pre-institution mediation, such period shall not be computed for the purposes of limitation under the Limitation Act. So this duration will stand excluded from the period of limitation for you to file your case. Para 4. If the parties to the commercial dispute arrive at a settlement, the same shall be reduced into writing and shall be signed by the parties to the dispute and the mediator. The settlement arrived at under this section shall have the same status and effect as if it is an arbitral award on agreed terms under subsection 4 of section 30 of the Arbitration and Conciliation Act 1996. So, before I say anything more about this section, there's one point I want to make, which is that this section has been amended by the Mediation Act 2023. And how it is amended is to say that under this law, it is a legal services authority that will administer pre-institution mediation. So you must go to the legal services authorities if you want to initiate or start mediation for a commercial dispute. Now, the Commercial Courts Act the Mediation Act, which amends this section, says that you can also take your pre-institution mediation in a commercial dispute to a mediation service provider that is set up under that law. So just keep that in mind. We will go into who this mediation service provider is when we discuss the Mediation Act. So that's the change. So in summary, what does 12A say? It says if you have a commercial dispute, you cannot file that case unless you go for pre-institution mediation. You will go for pre-institution mediation to the Legal Services Authority. But if you need some urgent order from the court, then you don't need to go for pre-institution mediation. Please file your case directly in court and ask for your urgent interim order. Mediation will be completed within 3 months, but if you're not able to do it within that time, you have an extension of another 2 months if all parties agree. The limitation period, for the period that you have spent in mediation, that will be excluded for limitation. If you enter into a settlement agreement, the parties will sign it, and it will be signed by the mediator. And this settlement agreement will have the same status as a settlement agreement under the Arbitration and Conciliation Act, Section 30. Now, just give me a minute. Yeah. This is another change under the Mediation Act, which is that the settlement agreement will be enforceable as if it were a settlement agreement under the Mediation Act 2023. So that's another amendment to Section 12A. So as things stand, the Arbitration Conciliation Act in Part 1 deals with arbitration. In Part 2, Part 1 deals with domestic arbitration. In Part 2 deals with international arbitration or foreign awards and their enforcement. And in Part 3 deals with conciliation. And what this act says is that if you have conciliation and you enter into a settlement agreement at the end of this conciliation, that settlement agreement will be enforceable as if it were an arbitration award on agreed terms. Section 30 of the Arbitration Conciliation Act in Part 1 says that we will encourage parties to try and settle their disputes, and if they settle their disputes and ask the arbitrator to pass an award in terms of the settlement agreement, that has the same status and effect as if it were an arbitration award passed on the merits of the case, which is that it will be enforceable as if it were a decree. So until the Mediation Act 2023 and the relevant provisions are brought into force, as well as after, the effect is that the mediated settlement agreement under the Commercial Courts Act will be enforceable as if it were a decree passed by a civil court, right? So now these are the two laws that we're looking at that say, before you file your case in a certain category of disputes, please go for pre-institution mediation. Now, I want to ask you all, do you find a problem with this? Do you think it's necessary? And in each case, why? Yeah, Hemangi.
Madam, I think it is necessary in each and every case because it reduces the time in litigation at the time of at the same time cost also.
Okay, but it also means that I may not settle. I have to pay costs of the mediation. I have to spend, let us say, 5 months in mediation. Isn't that a problem? I don't know if I'm going to settle.
In some cases it may happen, but considering the type of transactions which are involved in Commercial Courts Act specifically, that it should be for this pre-institution mediation is required. I think 5 months time, and even the mediation cost is the lesser things comparative to litigation cost and litigation time. That's what I think.
Yeah, thanks, Hemangi. Anyone else who agrees, disagrees with Hemangi or disagrees with me?
I feel that this mediation should have been provided for after the initiation of litigation. Because
Okay.
pre-mediation, parties don't have a mentality to settle. They want to get into litigation. And once their pleadings and their reply is on record, thereafter, if you send to the mediator, even the mediator will know what is exactly their dispute.
Okay.
And what I have seen is that this pre-mediation is merely a formality which the parties enter into, and thereafter they enter into litigation depending upon their capacity, or they even don't enter into litigation. I have seen cases where in the mediation they pay the money for the mediation, and thereafter they don't have the capacity to get into litigation because of the cost. So they just wind it up there itself. So the parties' right to litigate gets hampered there. That is what I feel.
Okay, so 2 points that I'm getting from you. The first is that when you insist that they have to go for mediation, or rather three, parties want to actually litigate, and they're really not interested in this mediation, and therefore, the second point, they will just stick this as, okay, I've filed it. You told me I had to, so I've done this, but I'm really not going to make any effort here. Once I've ticked this, this mandate or this requirement, I will now proceed to litigation, which is where I wanted to go in the first place. And the third point you make is that litigation, mediation all involve costs. And if you make the party pay these additional costs in mediation, that might affect their ability to litigate because they've already forked out a lot of money for the mediation. So that's another point. Thank you. Anil?
Yes, ma'am. According to me, if mediation is successful, then the burden on the courts will be reduced. And if it is unsuccessful, then in that case, who will bear the cost will be decided, and that will be act as a deterrent for the parties to go for suit filing and going to the court. Everyone will probably try for the mediation.
Okay. So the possibility of settling is great, and we also need this because we want to reduce the pendency in our court. So this is not so much a mediation policy as much as it is a dealing with pendency policy, right? Any other thoughts on this?
Ma'am, I'm
Ma'am?
Sandeep.
Yeah, sorry. Yeah, Krishna.
Madam, I think mediation is in preliminary stage. So making it mandatory, by the time it will take very good shape actually. This is a good condition so that the small disputes will be settled very early and there will be no burden on the litigation actually.
Okay, so since you speak about small disputes and the burden on thing, let me also talk to you about the MSME Act. The MSME Act says that, so it's a law that is there to sort of safeguard and make provision to ensure that micro, small and medium enterprises are protected, that there is regulatory support for them. So insofar as money that is owed to micro and small enterprises is concerned, the law says that they must go with their dispute to, so if the money is not paid to them for goods or services that they have provided, they take that dispute to what are called facilitation councils, which are to be set up in every state. And this facilitation council will first try conciliation, and if the parties don't settle the disputes in conciliation, it will go for arbitration. So the point that Krishna Kumar makes is that in smaller disputes, smaller value disputes, where people don't have the capacity to wait for litigation or to bear the costs of litigation, this is a good way of attempting to resolve your dispute, right? So there is a designed policy around, the situation that you have sort of identified, right? Okay, thanks for that. So you're breaking up, and in fact, I think this is a point Himangi has well made, that in commercial disputes, certain categories of disputes, it's a good place or a good type of dispute for us to have mediation. Anurag?
Yes, ma'am. I would like to extend Madam Himangi's view only, that in commercial disputes where emotions are less, pre-mediation is successful. It's like, but in other cases where it's a personal litigation, pre-mediation usually is not taken in that sense by the parties. Even if its court is mandated, say family courts, say in consumer commission, but say inversely in consumer commission related to public utilities, electricity theft case is there or something. This is a very successful thing. In commercial other things also, it is very successful. So it has floated very well, but it needs education or awareness or effort on part of the dealing hands, like advocates, who are the first dealing hand with the parties or the person seeking justice. Then it would be making a difference. But the start is good. we should support this. Pre-mediation is a good concept.
Okay, so 2 points
That's
you
why.
make.
Thank you.
First is that in certain policies, and you make, certain types of disputes, and you make the point about consumer disputes, and in particular, consumer disputes with public utilities. This is a good place to have mediation because um, parties' capacity to go through the rough and tumble of litigation, you give an opportunity for them to avoid it, to bypass it, and settle their dispute. There was something I wanted to say in this context. Okay, it slipped me. Mukta?
Ma'am, like I agree with Mr. Gokuldas, where he has pointed out that in most of the cases in commercial disputes, the parties intend to litigate rather than to settle or mediate. Because even there is a provision for mediation, the parties are represented by people who don't have the full liberty and power to mediate. The representatives of parties don't have they don't come with full authority to mediate and settle the cases. So this is a time consuming process. It takes a lot of time, 1 sitting, 2 sitting, 3 sitting. And every time they should get new powers, new power of attorneys. So this is what happening actually. And court directing us, with a statute to go for a pre-institutional mediation is like curbing my own freedom to litigate.
Okay.
So if the parties are really intentional to settle, I include in all my contracts or whoever the party, a provision for mediation in the first instance itself. But when there is no such provision between the parties, the act is interfering in the liberty of the parties to mediate. This is what I feel.
Yeah. So 2 types of liberties that you talk about, Mukta. The first is the liberty or the freedom to mediate. It is a freedom to mediate. It is not a compulsion to mediate. And the second is that the point you make in terms of freedom is I should have the freedom to go to court. That is my right. Can a law interfere with my ability to go to court? I'm glad you brought this up because this is something that is a little more serious, right? Can a law say, no, you cannot go to court? Is that not my fundamental right? Is that not a right, that safeguards my interests, my other rights? So can you say, no, you cannot go to court unless you do this, that, and the other? Which is the case with the Italian law. It is a case here as well. Let me talk about, one of you also spoke about the lawyer's responsibilities. So the Italian law requires lawyers to point out to their clients when someone comes to them with a problem, 2 things. One is to say, look, there is this mediation process available. You can try it. It's good to try it. This is what the benefits are. This is what the benefits the law provides. The second thing that the lawyer must also inform them is, look, you've brought a dispute in this category where it is mandatory for you to go for mediation. So you have to go for mediation. So this is a responsibility the lawyer has. There is another law in Australia, which is called the Civil Disputes. What's the full law? It mandates that you take legitimate or proper steps to try and settle your disputes before you file your case in court. And it is the responsibility of the lawyers to tell the parties that, look, before you file your case in court, the law mandates that you take some steps to try and resolve this, reasonable steps to resolve your dispute. And when I file my case in court in Australia, I must give a statement that, look, these were the steps I took to try and resolve the dispute, which will include negotiation, mediation. And if the lawyer has not advised the party about it, the lawyer will have to pay the cost of the litigation. And the lawyer cannot take it from the party. So the law says all of this, right? So the question is this an interference with your right to go to court? Sorry, Himangi and Gokuldas, please go ahead and then we'll.
Ma'am, I would like to...
Okay, Himangi, you can proceed.
Madam, I would like to add one more thing that through settlement, both the parties will be benefited. by one or the other way. Sometimes in the litigation, one party succeeds and other party is loser. So mediation is benefited at the pre-institution stage for both the parties. It is my additional view.
Point. Okay, so there is value in mediation if you settle. Both parties are happy or both parties are together unhappy. So it's worthwhile doing it. Yeah, Gokuldas?
Yeah, I was saying that the primary role or responsibility of a state is protection of the individual and adjudication of the dispute. So when the state or when the government machinery is saying that they wanted to reduce the dependency of litigation, in fact they are avoiding or they are getting away from their primary responsibility of adjudication.
Right. Okay, fair point. Are they shirking their responsibility when they say go for mediation? So that's the other question. So this question about whether this any law that says you must go for mediation, interferes with the person's right to be able to go to court. Is that a fundamental right, or is that a legal right? Is this right affected or defeated if you say no, you can't go to court, you have to go for mediation? This was a question that was, sorry, Venkatakrishnan, you complete and then I'll go ahead.
Yes, madam. Madam, of course, being a non-legal professional, one question I wanted to ask. As a businessman, let us say, I ask this question. Now, when the parties are in mediation, how will someone control the person on the other side who's, let's say, on slightly a weaker side, or somebody who's got a stronger way to influence the other side, other person, maybe through his lawyers? So who's going to regulate or monitor them?
I would say it would be monitored by the mediator, but that's not something. I would say it would be monitored by the mediator. It's not something we were going to discuss today. That's why I'm not like getting into.
Okay, so no, it's a thought that came up.
No, it is an important thought. It is important. Let us look at. In fact, a lot of people, particularly in women's rights, have raised this and squarely and properly raised this issue. In disputes relating to domestic violence. So if you have the domestic, the partners or the spouses sitting in a mediation, and there is one person who has been subject to domestic violence, mental, physical, and we talk about it in a very, in an intellectual space or in a conversational space, or as a bylane to our conversations on mediation. But it can be terrifying, it can be crippling for the person who has been subjected to violence. And they say we have agitated and tried to get policymakers to recognize that there is something called domestic violence, and that this needs to be addressed, that law needs to step in, and we've managed to get certain rights for the women this way. Now you tell them go sit in a mediation, even though this person has been subjected to domestic violence. You think she will be able to negotiate with her, with the person who has bullied and beaten her up all this time? Do you think she will be able to do it? And that's a fair question. And I think it would be the responsibility of the mediator to watch out for these signals and say this may not be the right dispute for mediation. Right? And this is probably, we should not be going ahead with this mediation. So I think that's a responsibility of the mediator to keep an eye on this kind of things. So the process manager is the mediator, and this is one aspect that they will keep in mind. Anil?
Yes, madam. In my opinion, whether it is a right or it is an opportunity or anything, that is not absolute. Taking into account the larger interest of the society, we can put riders on the freedom.
Okay.
So depending upon the case, as you suggested that the lawmakers, they can take into account cases where mediation will not be a successful thing. So initially itself, they can exclude those cases like domestic violence and criminal cases. But for others, mediation is okay.
Right. So we're linking 2 or 3 aspects here. The first relating to imbalance of from what Venkatkrishnan said and what Anil says. There may be certain disputes that may not be amenable or appropriate for mediation. At the policy level, we keep it out. But where we decide that this is a good dispute sector or a vertical where we can have mediation, the right, Anil says, is not an absolute right to go to court. For other policy reasons, other public interest reasons, you can say that I am going to interfere or restrict this right slightly so that you are able to try some other way to resolve your dispute. That is also good for you as litigants or as disputants. So you can make these restrictions. So this is a question that came up in a case. So we've had a lot of cases on Section 12A of the Commercial Courts Act. And one issue that has really troubled the courts is, can a person who does not need urgent interim orders bypass the requirement of Section 12 capital A by saying, no, I need this urgent interim order, so I'm filing this case in court. And then you find that actually that was only a ruse to avoid the requirement of Section 12 capital A. And the courts have said 12A is mandatory. If you have a case, a commercial dispute, you must go for mediation unless you have an urgent interim order that you require. In fact, more recently, I think it's a Delhi High Court, I think last week has said that if you have a counterclaim, which is in the nature of a commercial dispute, even then you have to go. You may be the responding party, but then you are making a certain claim against that party. You have to go for mediation before you file your case in court. How that actually works out, we need to see. But number one, this is mandatory. The Supreme Court has said so. The second is, the Supreme Court has said, when a case is filed in court, the court will look at what is this interim order that you're asking for, because of which you couldn't go for pre-institution mediation. And the court will assess, was there a need for you to have filed this application, or is this just one way of avoiding or evading 12 capital A and not going for mediation? So this is a responsibility of commercial courts now because of the Supreme Court judgment. When a commercial suit is filed and there is an interim application because of which the party has not gone for pre-institution mediation, the court must look at the application to see if genuinely there is a need for, not the merits as much as genuinely there was a need for this interim order. And if it finds that this interim order was really not necessary, it will reject the case, right? So these are sort of the principles on which, principles that courts have laid down in Section 12 capital A cases. The case that I want us to look at now, we'll probably take a 5-minute break. But after the break, the case that I want us to look at is a case of Rosalba Alicini. Again, the link has been provided to you. This is the European Court of Justice, which has given a case where the same question was asked. Is the requirement of mandatory mediation something that interferes with a person's right to go to court? Right? So let us see what they say about what Anil said about the right to go to court. Okay, so it's now 5:58. We will rejoin at about 6:03. Or would you want a longer break? That's also okay. So if you want to have a break till about 6:05. Yeah, so we'll rejoin at 6:05. Thank you. So we'll continue. So in this case of Rosalba Alicini was a case where there was a universal telecom directive, and Italy had made a law where it said that if there is any complaint against a telecom service provider, you will first go for out-of-court settlement processes, and if you're not able to resolve this dispute through these out-of-court settlement processes, only then will you file your case against this service provider. So this was challenged by several people, including Rosalba Alicini. And the question that was was raised before the court, the European court, was, is this establishment of a mandatory settlement procedure, which is a condition for filing any action before the court, is it compatible with the right to effective judicial protection? So the right to be able to go to court is a right that is given to persons in the European Union under European Union law. You have a right to be able to go to court. So does this requirement that you must go for out-of-court settlement procedures interfering with that right? So the court went into what this process was, how this process works. And the court said, and this is at page, it's not numbered, but there is a paragraph which is there on the left in smaller numbers. So I'm at paragraph 52, if you are able to come there. If you're able to identify it. If there's a problem, just let me know, because I sent you the link and I had downloaded this some time ago, and it may not be the same source. Yeah, okay, thank you. So the principles that the court looks at to decide whether this is an interference with the right to be able to go to court, which is a right given to persons in the EU. It says, in this case, we find that it is not an interference with the party's right to be able to go to court. And the reasons for it are these. The first is, it says that as regards the principle of effectiveness, it is admittedly true that making the admissibility of legal proceedings conditional upon the prior implementation of an out-of-court settlement procedure affects the exercise of rights conferred on individuals by the Universal Service Directive, which is access to court and access to be able to get your disputes with this service provider, with the telecom service provider, resolved. However, various factors show that a mandatory settlement procedure such as that at issue is not such as to make it in practice impossible or excessively difficult to exercise the rights which the individuals derive from that directive. First, the outcome of the settlement procedure is not binding on the parties concerned and thus does not prejudice their right to bring legal proceedings. And what they mean by this is that you are mandated to go for mediation or for settlement, but you don't have to settle. So a lot of people who are proponents of mandatory mediation say that, please, I think you're misconstruing mandatory mediation. It is not that you're mandated to settle in mediation. You're mandated to take a step in mediation and to start mediation, but you're free to leave when you want to. You're free not to settle in the mediation. Therefore, don't call it mandatory mediation. In fact, in Italy, the proponents of mandatory mediation say that it's actually opt-out mediation. You go for mediation, but you're free to opt out, right? So that's the point that this judgment also makes. Secondly, the settlement procedure does not in normal circumstances result in substantial delay for the purposes of bringing legal proceedings. The time limit for completion of the settlement procedure is 30 days as from the date of the request, and on expiry of the deadline, the parties may bring legal proceedings even if the procedure has not been completed. Thirdly, for the duration of the settlement procedure, the period for the time barring of claims, which is limitation, is suspended. Fourthly, there are no fees for the settlement procedure before the code.re.com. In the case of the settlement procedures before other bodies, there is nothing in the documents before the courts to suggest that they entail significant costs. However, the exercise of rights conferred by the Universal Service Directive might be rendered in practice impossible or excessively difficult for certain individuals, in particular those without access to internet. If the settlement procedure could be accessed only by electronic means, it is for the referring court to ascertain whether that is the case, having a special regard to Article 13(1) of the dispute settlement rules. So, there is a digital divide in every country where there are people who can access internet and online dispute resolution mechanisms, but there are persons who may not be able to do so. And so, we must, the court says, look into whether this is a hindrance or a handicap for people in accessing the out-of-court settlement mechanisms. By the same token, it is for the referring court to ascertain whether in exceptional cases where interim measures are necessary, the settlement procedure allows or does not preclude the adoption of such measures. So if you need some urgent interim order, for instance, if your telecom service has been suspended and you need that to be reinstated urgently or to be considered urgently, the out-of-court settlement mechanism should not come in the way of your being able to get that urgent order considered or urgent measure considered by the court. In those circumstances, it must be held that the national legislation at issue in the present case complies with the principle of effectiveness insofar as electronic means is not the only means by which the settlement procedure may be accessed, and insofar as interim measures are possible in exceptional cases where the urgency of the situation so requires. Now the point that Anil made, and this is that paragraph 63. It is settled case law that fundamental rights do not constitute unfettered prerogatives, and they may be restricted provided that the restrictions in fact correspond to objectives of general interest pursued by measures in question, and they do not involve, with regard to the objectives pursued, a disproportionate and intolerable interference which infringes upon the very substance of the rights guaranteed. So the point made by the court is that we look at and you know, these are useful guidelines for any court to look at when they are seeing whether mandating mediation interferes with the right to access courts. So they talk about, they don't say, no, it does not interfere, or yes, it interferes. They say we are looking at what this mechanism is. It doesn't take too much time. It isn't expensive. It allows you to exercise rights to get your interim reliefs. It doesn't take too long. These are, if these kind of aspects are sort of safeguarded and provided for in the policy, they say then the policy will not affect your right to access courts. So when we look at our policies as well, and this is probably an exercise that all of you can undertake, is to look at the Rosalba principles, Rosalba norms, to check if the policy on mandatory mediation, which is there, say, in the Commercial Courts Act or in the Italian decree, is it really so onerous on parties, or are there these safeguards that the Rosalba judgment identifies? So you can evaluate these laws to see where they stand insofar as these guidelines are made by the Rosalba judgment. So this is all that we will discuss in terms of mandating mediation in the policy. We will now look at our Mediation Act. Just to compare what the policy in our law is. So if we go to section 5, please let me know once you have that open. Okay, thanks. So if you look at Section 5 of the Mediation Act, it says that subject to the other provisions of this Act, whether any mediation agreement exists or not, and that's an aspect we'll look at a little later in the class, the parties before filing any suit or proceedings of civil or commercial nature in any court may voluntarily and with mutual consent take steps to settle the disputes by pre-litigation mediation in accordance with the provisions of this Act. So this is very different from the policies we've looked at so far. Before filing a case in court, the parties to the dispute, if all of them are agreed that they want to try mediation, they can try mediation. So this is a law that is facilitative. It doesn't mandate. It says if you wish to, please try mediation. The earlier version of the bill, which was introduced in the Rajya Sabha, said mandatory mediation for civil and commercial disputes. But the parliamentary committee that went into this bill, because it was referred to them, this committee went across the country, spoke to lawyers, spoke to mediators, spoke to judges, also spoke to the government. So it heard the views of all these different stakeholders, and it proposed that the provision in the bill of mandatory mediation be removed. And they said, attempt it sectorally, attempt it bit by bit. We don't even have the infrastructure. If you say it is mandatory, where will the people who have commercial disputes or civil disputes go? We don't have enough mediators yet. So please put that aside for the present. And this is something you can look at a later point in time, which is what was done by the government. They have removed mandatory mediation. So it says that before filing a case, if you think you want to attempt mediation and all parties to the dispute agree, please go attempt mediation. It also says that, look, the Commercial Courts Act provides for mandatory mediation. Please follow what is required to be done under that act. If it is a commercial dispute, that falls within that law. The next section that I would like us to look at is Section 7. This is the power of the court or tribunal to refer parties to mediation. Notwithstanding the non-settlement of dispute under subsection 1 of Section 5. So people may have attempted mediation and not settled. So it doesn't matter. You've come to court now with your dispute. The court or tribunal may at any stage of the proceeding refer the parties to undertake mediation. If the court or tribunal refers the parties to undertake mediation, it may pass suitable interim orders to protect the interest of any party if deemed appropriate. The party shall not be under obligation to come to a settlement in the mediation pursuant to the reference under subsection 1. They have to go for mediation, yes, when the court mandates it. They don't, it's not required that they settle. It would have gone without saying, but the section itself says you may be directed to go for mediation, but whether you settle there or not is your prerogative, right? So this is the Mediation Act insofar as mandatory or voluntary mediation is concerned. Very strictly voluntary, but the courts have the power to refer the parties to go for mediation, right? We'll now go to the second sort of limb of mandatory mediation, which is enforcing an agreement to mediate. So if parties have a commercial agreement or any agreement that governs their relationship, their rights and their obligations, and that agreement makes a provision for mediation to resolve their disputes, should they be prevented from filing a case in court without attempting mediation? What are your thoughts? So when they entered into, let us say, a distribution agreement, they say when disputes arise, we will take this dispute to mediation. If we are not able to settle in the mediation, then we will take it to arbitration or we will go to court. So there is this agreement between the parties. Dispute comes up. Should you force the parties to go for mediation? let's assume you are the court or you are the policy maker, should you force the parties to go for mediation because they have an agreement?
Yes, madam. When they have the agreement, they should first try it, no?
Okay.
Yes,
Ma'am, if
ma'am.
both the
If they have
parties,
agreed to get into arbitration, into mediation, I think the court should tell them to get into mediation first.
They should tell them. Like Section 8 of the Arbitration Act, court should not do anything with the agreement, with the case, and say, please go for mediation, and then if you're not able to settle, come back. Any, Keshav?
Am I audible, ma'am?
Yes, you are.
Ma'am, if they already have an agreement, first of all, they should try to resolve it through mediation. End of the day, they want to resolve a problem or a conflict rather than to keep fighting. A rational person would want to. So I think that's mandatory mediation is a better option.
Okay. Anyone else who has a different view, Anurag? I hope you're going to have a different view. So that...
No, man. And not a different view, but it has got some offshoots to the views already presented. Actually, we are talking about the validity, sanctity, or some kind of thing, or we can say morality of the, if we should pass, or legality of procedural things. But we should not skip the step mandated by law or statute, because it not only has implications right now in the present time, but at a future time also, in the future also, at any stage of litigation. So if a party denies to enter into mediation despite having an agreement, at a later stage an inference could be drawn out of it, say after 2 years. Any inference could be drawn out of it. It usually happens in consumers and in family court matters.
What
We have tried.
What kind of inference can be drawn?
So I can give you example. Say there is a matrimonial case. So after a 1.5 approximately, or you can say 2 years of litigation, an application was moved by the husband to try the matter in the mediation. Okay. But it was refused by the wife. On what basis? On the basis that the pending dues of maintenance has to be cleared first. Okay. Thereafter, I can think about it. So the dues were paid by the husband within 3 months. Again, an application was pressed. This present application was pressed. A new application was also made. But the wife clearly told that I do not want to enter into mediation with this person. As you pointed out in DV cases, it is we can think the offshoot of the, or outcome of the life of the incidents. Now, the case went on and the husband didn't have any proof of the many things he want to prove in the divorce proceedings. So he just put that denial of the wife onto the record. So things were easy for him. Henceforth, I think, not to reveal the total strategy of the case here on a public platform. So similarly is the thing in commercial matters. It also, suppose I am at loggerheads with my contractor. I am a company. I am a representative of a company. We have a mediation settlement agreement, subsequent arbitration. These clauses are there. A dispute arose. So these clauses are meant for that dispute, envisaging that kind of dispute. And at that point, if somebody tells, the other party tells, I am not inclined to enter into mediation despite having a contract, whatever may be the issues in the dispute, will I be considering him again for a relationship? Commercial relationship. Okay. So these are the things. This issue is not valid, or we should ascertain based on it decides the present relationship. It decides the future relationship. Okay. That's what.
Okay, that's useful. Any of you think that if the court says go for mediation, Let's look at Section 8 of the Arbitration and Conciliation Act. There the court says, go for arbitration. Why? Because that's a dispute resolution process where there will be a definite outcome. There is an arbitrator, the arbitrator will decide one way or the other, and you have an outcome that is that substitutes or is similar to what you would have got in court. The arbitrator has power to pass interim orders, the arbitrator has power to decide the dispute. So if the court under Section 8, or if the Section 8 policy is that if there is an arbitration agreement, please go for arbitration, there is some outcome there. But in the case of mediation, what's the point? I wasn't interested in mediation, that's why I filed the case in court. You're telling me go for mediation, I'm going to go there and I'm going to say I'm not interested, which I'm entitled to say, and I'm going to come back. Why waste all this time? Why waste money? Why waste effort? Are you going to get a settlement if you direct parties to go for mediation? So is there any purpose in doing this? In saying if you have an agreement to mediate, you must mediate. What are we going to get out of it?
A denial, ma'am.
A
denial.
Okay, you get a denial to mediate.
Which can be used somewhere.
We will look at what that denial, where the denial can be used, because the policy supports that, right? And that we'll come to next, which is the courts regime. But other than that, you're not what can the court do? Court can't control anything. Court can only say go for mediation. So I go and I say I'm not interested in the mediation, I come back, which I'm entitled to say.
Madam, what is the success rate that will count? That is the question. 20%, 30% if you succeed, whether it is success or not. For the initial stage of this process. This is initial stage. Any initial stage is a problem. If you remember, the Consumers Act came, there was a provision that no lawyers will come there. So the lawyers went on a strike and destroyed the whole concept. And it is now as if like the same litigation case. So it's anything beginning is a problem. But what I said, what is the percent success which will count as a success?
It varies across the country, and I'm only I'm saying this in the context of court annexed mediation, right? But I take your point slightly differently, Satyajit. And the point I take is that go there, you don't know what will happen. You don't know. I may say I'm going to pull out in the first meeting, go there and say I'm not interested, now terminate it, which I'm well within my rights to say. But then the point you make, and that's what I draw from your comment, is that who knows? Go there, let's see. Right? 20% of the cases settle, 30% of the cases settle. Yours could be in that 20%. Right? So that's another way of looking at it. Right? So I have two judgments. Yeah, Anil?
Yes, madam. I am doing mediation for NSE cases relating to stock market and investments and complaints and disputes between the investor and the trading member. And whatever cases have been entrusted to me, the success rate of mediation is 10 to 15%. This is what I observe.
Yeah. But what Satyajit says is take what do you call it? What's the word for it? Take hope.
Lion's share.
Take what's the word? Yeah, take hope, take encouragement from that 15% or the 10% that you've settled. That is what he says. And therefore go, try it out. Right? So, Hemangi?
Ma'am, when we are entering into particular agreement and stating that first mediation should be given or we should go for that, it means that mentally we are prepared to go for the mediation at a preliminary stage. So we can take that chance. Positive.
Yeah, okay. That's great. So, in India, we look at what the law is over here. If we look at section 4 of the Mediation Act, that talks about a mediation agreement. So what we were talking about now, it says a mediation agreement shall be in writing by or between parties and anyone claiming through them to submit to mediation all or certain disputes which have arisen or which may arise between the parties. A mediation agreement may be in the form of a mediation clause in a contract or in the form of a separate agreement. The rest is all, how the mediation agreement is constructed. Paragraph 5 I'm coming to in section 4. The parties may agree to submit to mediation any dispute arising between them under an agreement, whether entered into prior to arising of the dispute or subsequent thereto. And in para 6, a mediation agreement in case of international mediation shall refer to an agreement for resolution in matters of commercial disputes referred to in clause A of section 3. So section 3 clause A talks about what an international dispute will be, and we will come to that separately when we are looking at the Singapore Convention in one of our later classes. Section 4 now talks about a mediation agreement. Now, is this mediation agreement enforceable? No, because if you look at section 5, and we read this a little earlier, subject to other provisions of this Act, whether any mediation agreement exists or not, the parties, before filing any suit or proceeding of civil or commercial nature in any court, may voluntarily and with mutual consent take steps to settle the disputes by pre-litigation mediation. So you may have an agreement, but all parties must at that stage agree that they want to go for pre-litigation mediation and not file the case in court. So though you have a section dedicated to mediated agreement, nothing comes out of it. Okay, it cannot be enforced. You can't force a person to go for mediation of the kind that you have, or of the nature we have in Section 8 of the Arbitration and Conciliation Act. Right? Initially, the bill actually made a provision for enforcement. But in the way they have revamped it, there are a lot of problems. We'll come to some of them. One is that you have one section that deals with the mediation agreement. We all think, me included, we all think that when there is such an agreement, you must ask the parties to go try mediation, right? But nothing comes out of it here. So when they were removing things, I think in editing it, there has been a problem. Okay, so the same issue came up before courts in England, and in the first case that came up before, in one of the earlier cases that came up before the court in England, there was an agreement that they will negotiate certain items. They were negotiating an agreement, and they said, yes, we agree that we will have the contract with you. We just need to identify certain other items we need to negotiate and finalize those aspects, then we enter into an agreement. Now, the other party to that agreement didn't go ahead with that agreement with this first party, and without even negotiating with them, it signed the contract with someone else. It was an agreement to sell a shop or a business relating to photography. So this elderly couple that owned the business, they had started discussions with a particular party, and they said, okay, we will sign the agreement with you. There are certain aspects that we still need to negotiate and settle. But instead of signing the agreement with this party, they went and signed it with some other party. So this party files a case in court and says, look, they agreed that we will negotiate these items and we will enter into an agreement. They had agreed to negotiate with me on these aspects. Now they're pulling out of it. They have breached their agreement. The court says, look, I cannot pass an order saying go negotiate. Of what value is my order? Because whether they will negotiate, whether they will not negotiate, whether they will come sit and say, I'm not interested, then what is the value that my order has? It amounts to nothing. So I will not pass an order saying, go agree to agree. You have an agreement, I will enforce that agreement where you have to go agree to something, negotiate and agree upon something. So this was one of the earliest cases that, and this was the approach that the court took. And the argument made when there was a case before the court where there was an agreement to mediate was, you're telling the person, if you're enforcing this mediation agreement, you're telling the person to go to agree to agree. You cannot manage that and you should not enforce it. So the first judgment that we look at which considers this question is Cable and Wireless versus IBM. Let me know when you've opened it. Okay. I have a Word document for this judgment, whereas I've given you an open access link. So if you're able to find it, fantastic. What you could search for is the application to stay the proceedings. If you can type that in your PDF and find it, let me know, and then I'll go on from there. Otherwise, you can just, read this at your leisure, and I will read very slowly so that, we can.
Yes, ma'am, it is page number 4 of it is there.
It is there? Okay.
Yes, page number 4 for everybody.
Okay. So the heading is the application to stay proceedings, the heading that the court. So let me give you the context. Cable and Wireless had engaged IBM to provide certain services, and there was something called a standardization clause where every year they would evaluate what is being paid to IBM, and they would look at what are the services provided, they would look at what is a comparison in the industry, and they will have to reevaluate it. So there was a dispute between them on the services provided, and this is what the contract between both of them said. The application, so when the dispute arose, this dispute was, a case was filed in court saying, look, there is this dispute, please decide this for us. Now, the other party, Cable and Wireless, filed an application saying, no, you cannot go ahead with the case, like a Section 8 application. It said you cannot go ahead with this case, and because we have an agreement to mediate. And what is this agreement to mediate? The application for stay of the present proceedings is founded on clause 41 of the GFA, that is the agreement between both of them. This provides as follows. The parties shall attempt in good faith to resolve any dispute or claim arising out of or relating to this agreement, or any, Krishna Kumar, can you just put your phone down? Yeah, thank you. The parties shall attempt in good faith to resolve any dispute or claim arising out of or relating to this agreement or any local services agreement promptly through negotiations between the respective senior executives of the parties who have authority to settle pursuant to clause 40. If the matter is not resolved through negotiation, the party shall attempt in good faith to resolve the dispute or claim through an alternative dispute resolution procedure as recommended to the parties by the Center for Dispute Resolution. So this is the agreement between both the parties, that they will go to this organization called Center for Dispute Resolution, CEDR, CEDR, which is there in the UK, and they will follow mediation or arbitration as is suggested by CEDR. CEDR was a is a well-known private organization that provides mediation services. So now the court is now sort of considering whether it should stop the case and ask them to go for mediation. In the next page, there is a paragraph starting with Mr. Timothy Dutton QC. So this is the lawyer for Cable and Wireless who has filed the case, and he says, he submits that clause 41.2 is unenforceable because it lacks certainty. It imposes no more than an agreement to negotiate, and he submits on the authority of the judgment of Stein, J. and Paul Smith versus H&S International Holding Incorporated, and the earlier decision of the Court of Appeal on which it was based, Courtney and Fairburn Limited versus Tolani Brothers Hotels Limited, that an agreement to negotiate is not enforceable in English law. So the principle that I was saying earlier, the court will not do something which it cannot make the parties do, right? So in spirit, it can't do anything that the parties don't want to do. So a court will not pass an order that will be of no effect. So we don't pass such orders. Now I'm coming to further down to the subheading that says analysis. And the second paragraph under analysis, which starts with, there is, however, another basis. There is, however, another basis for the submission. You have it? Yeah, okay. So the court says, there is, however, another basis. Now, analysis is what the court is now sort of arguing around the issue for itself and then coming to a decision. There is, however, another basis for the submission that the reference to ADR is of no binding effect. Essentially, the question that arises is whether that reference is in substance nothing more than an agreement to negotiate, and as such, an agreement incapable of enforcement in English law is decided by the Court of Appeal, and the case is named. The starting point is a wording of the reference to ADR in clause 41.2. This is clause 41.2 of the agreement that we saw. It is to be observed that the parties have not simply agreed to attempt in good faith to negotiate a settlement. In this case, they have gone further than that by identifying a particular procedure, namely an ADR procedure as recommended to the parties by the Center for Dispute Resolution, to which I refer as CEDR. That is one of the best known and most experienced dispute resolution service providers in this country. It has over the last 12 years made a major contribution to the development of mediation services, including mediation methodology and consultative services available to parties to disputes who need advice both on a choice of mediator and on appropriate procedures for mediation. Indeed, at the time when the GFA was entered into, CEDR had published the 6th edition of its model mediation procedure and agreement. This sets out a model procedure which specifies the terms upon which the parties may proceed with reference to the mediation. And then it extracts everything about how the mediation will be conducted. And if you come down to three or four paragraphs below, which starts with the sentence, there is an obvious lack of certainty. Yeah? There is an obvious lack of certainty in a mere undertaking to negotiate a contract or a settlement agreement, just as there is in an agreement to strive to settle disputes amicably. That is because a court would have insufficient objective criteria to decide whether one or both parties were in compliance or breach of such a provision. So did you amicably attempt? Did you attempt in good faith to settle? We don't know. We were never going to know. No doubt, therefore, if in the present case the wording of clause 41.2 had simply provided that the party should attempt in good faith to resolve the dispute or claim, that would not have been enforceable. However, the clause went on to prescribe the means by which such attempt should be made, namely through an ADR procedure recommended to the parties by CEDR. The engagement can therefore be analyzed as requiring not merely an attempt in good faith to achieve resolution of a dispute, but also the participation of the parties in the procedure to be recommended by CEDR. Resort to CEDR and participation in its recommended procedure are, in my judgment, engagements of sufficient certainty for a court to readily ascertain whether they have been complied with. Thus, if one party simply fails to cooperate in the appointment of a mediator according to CEDR's model procedure, or to send documents to the mediator as is appointed, or to attend upon the mediator when he is called for a meeting, then there will clearly be an ascertainable breach of the agreement. So we are able to assess, did you follow what you were supposed to do or no? So there is more to, okay, why don't you try and settle, right? This may seem a somewhat slender basis for distinguishing this type of reference from a mere promise to negotiate. However, the English court should nowadays not be astute to accentuate uncertainty and therefore unenforceability in the field of dispute resolution references. There is now available a clearly recognized and well-developed process of dispute resolution involving sophisticated mediation techniques provided by trained mediators in accordance with procedures designed to achieve settlement by the means most suitable for the dispute in question. So the point that was made by some of you, go there, try it out. Who knows, you would settle. So let's work towards enforcing this. There is one more judgment. You can read the rest of it at leisure. It's a very nicely written judgment. There is another judgment that I have shared, which is OPEN, OHPEN, Open Operations UK Limited. If you could open that. Thank you. If you can go to paragraph 32 of this judgment. Do you have it? Yeah, okay. So in this case, the judge builds on what Cable and Wireless and cases after that say about enforcing an agreement to mediate. And it says, look, we've struggled with, can you enforce, can you make a party go sit in mediation and participate in mediation? We've started with, no, we cannot do something like that. Two, we have Cable and Wireless and later judgments that say, if there is a certain procedure, there is something you can see by which there are objective criteria that you are able to identify and say, yes, you must do A, B, C, D because you agreed to do that. That is your moral obligation. One of you mentioned that. That is your moral obligation. You at the time of entering into an agreement said that you will attempt to do this. Please go do it. Stand by your obligations under the agreement. So this court, what it says is, okay, I'm going to identify what should be there in an agreement to mediate, which will help the court enforce that agreement to mediate. That is, tell the parties, go do as you had agreed, right? And that is there in paragraph 32. The following principles can be derived from the above authorities as applicable when a party seeks to enforce an alternative dispute resolution provision by means of an order staying the proceedings. So the court proceedings will be stayed while the parties are asked to go for mediation. The agreement must create an enforceable obligation requiring the parties to engage in alternative dispute resolution. So it must be a must. The obligation must be expressed clearly as a condition precedent to court proceedings or arbitration. So your agreement must say, before we go to court, we have to try mediation. It is a must. The dispute resolution process to be followed does not have to be formal, but must be sufficiently clear and certain by reference to objective criteria, including machinery, to appoint a mediator or determine any other necessary step in the procedure without the requirement for any further agreement between the parties. So the agreement must be so clear that you don't need the court to say, oh, it was this, oh, no, it was that. So there should be no dispute between the parties about, no, this is what we meant, no, this is something else that we meant. So it must be clear where the court doesn't have to supplement or put in its finding about what the agreement really was. There must be clarity in the agreement. The court has a discretion to stay proceedings commenced in breach of an enforceable dispute resolution agreement. So it's important, this point. Even if you have an agreement where you say we will first go for mediation or alternative dispute resolution before we go for arbitration or litigation, even then, even if your agreement is very clear, the court still has the discretion to say, no, I will not stop the proceeding. Okay, and the court doesn't identify what sort of circumstances you will be able to not enforce this, but it goes on to say, in exercising its discretion, the court will have regard to the public policy interest in upholding the parties' commercial agreement and furthering the overriding objective in assisting the parties to resolve the dispute. So it identifies as public policy the responsibility of the court to, where parties say this is what we are going to do, this is their agreement, we will enforce it. And if there are other means by which parties can resolve their disputes, the court will lend its support in resolving it. But there is always a discretion with the court that even though there is such a clear agreement, they will not stay the litigation, but they will continue with the case. Okay, so this is open operation. So in both these cases, we see that when there is an agreement to mediate, the court is supporting it. The Singapore courts, the Court of Appeal there has also said that we will enforce an agreement to mediate. And there are objective criteria, even if it is an agreement for good faith attempt to settle a dispute, we will see what is a good faith. There are objective criteria, there are subjective criteria, but we will first make you go do what you said you will do and then come to the court to resolve your dispute. So the Singapore court has also taken a similar view. We have 9 minutes. I don't want to start the last subject because we may not be able to complete it, which is done it and racetrack, and the costs. Cost aspect in mandating mediation. So if there is anything you would want to discuss, we can do that in these 8 minutes. Yes, Venkatesan.
Madam, let us say any agreement, contractual agreement, which becomes voidable. Now, can they be subject to mediation?
So it depends on what basis it is voidable.
Okay.
So Venkatakrishan's question is if the parent agreement, so we'll take the example of distribution agreement so that the reference is easy. The distribution agreement has a mediation clause saying you must go for mediation, but the agreement itself is voidable. So there are grounds or there are situations under the Indian Contract Act when an agreement is voidable or a contract is voidable. That is fraud, that is coercion, there is undue influence, and there is misrepresentation. Okay, but my sense would be that if parties, so when an agreement is voidable, the person who has been the victim of fraud, coercion, misrepresentation, or undue influence has the right under the law to say, I will not go ahead with this agreement. But I'm guessing that if disputes have arisen under the agreement, the party who is a victim of fraud, undue influence, etc., has actually implemented the agreement and has not avoided the contract. And so I don't see a problem there with any dispute that has arisen there going for mediation. If that was your question.
Yes. Yes, that was a question.
I know that you are all, your experiences in different backgrounds. If this is very heavy in terms or very boring in terms of, law, judgment, do point it out and I'll see if I can do this a little differently. Okay, if there's nothing else to discuss, then we'll wind up today. Thank you, everyone.
Thank you.
Thank you, ma'am.
Thank you, ma'am.
Thank you, ma'am.
Thank you, madam.
Thank you, ma'am.
Thank you, ma'am.
Thank you.
Bye.